So back to 13, request 13. In Commonwealth's bottom half of page 5 and A on page 5 to 6, the court will give the language in A, which I think is the same as request 13, with one exception. Because this is a joint venture, the court on number 1, element number 1, will instruct that the defendant knowingly participated in the commission of an act that caused the death of Odin Lloyd. The court will give B.
Your Honor, I'm not, what the court just said, is that part of the model instruction?
It isn't, because the model does joint venture and then does cause, and doesn't merge cause, because obviously the definition of cause
I guess I'd ask the court to not to deviate from the model and to give the instruction that's given to the model on that.
Well, you need something.
Well, the court is giving a joint venture instruction elsewhere.
Right, but it needs to get integrated into I don't mind tracking the model, but I would add a sentence so they understand when I say the defendant caused, and a defendant's act is the cause where the act without which the death would not result. I think there needs to be some reference back to the concept of knowing participation.
Well, I guess I'd want to see what the court had in mind.
Well, what I had in mind was, and what I've done in numerous joint venture cases, and what other judges have done, is integrate the joint venture language with the element of cause and put the defendant knowingly participated in the commission of an act that caused the death of Odin Lloyd, and then in discussing it, indicate the first element is the defendant knowingly participated in the commission of an act that caused the death of Odin Lloyd. Please apply the instructions I've already given to you as to what the Commonwealth must prove to establish knowing participation. An act is the cause of Mr. Lloyd's death, where the act in a natural and continuous sequence results in death, and without which death would not have occurred. There are various places in the model where there has to be some cross-reference, or the language makes no sense.
Your Honor, the Commonwealth agrees with that, and I think it's appropriate, because if not, it's
but it's not the language you suggested.
No, Your Honor, and again, because we tracked the model, and that was an oversight on our part, but I think the court has rightfully said, well, we're giving them the joint venture. That has to be incorporated in understanding the individual elements of the crime of murder.
So I can either do the language I've suggested, which I've done in the past, and I know other judges have done in the past, or I can kind of try to construct something new, keeping the language of the model, but adding a sentence.
Well, I'd like to, I understand what the court is saying. I guess I would just like to see, have an opportunity to review and address the language that the court decides to use, but I think that...
Well, is there an objection to the language I've just read to you? Is that not all?
The objection, could you read it again, please, Your Honor?
Sure. Element number 1 is the defendant knowingly participated in the commission of an act that caused the death of Odin Lloyd. The first element is the defendant knowingly participated in the commission of an act that caused the death of Odin Lloyd. Please apply all the instructions I've given to you as to what the Commonwealth must prove to establish knowing participation in the commission of an act. An act is the cause of Odin Lloyd's death, where the act in a natural and continuous sequence results in death, and without which death would not have occurred.
Your Honor, could I just speak to my colleague for
Sure.
1 minute about that? Thank you. Your Honor, we would object to that language. We would ask the court to follow the model on this, and if the court...
I will follow the model, but I will then add a sentence, because it's on all of these. The defendant committed the killing, as opposed to the defendant knowingly participated in the commission of the killing. I will use the model language, but then I will add something to the effect that when the court uses the word cause or committed, as the court instructed, the Commonwealth is not required to prove the defendant. The sort of first couple of sentences from the joint venture instruction.
I think if the court wants to say that, before the court launches into this entire specific instruction, I don't have a problem with that. I don't think the court should repeat it each and every time it
No,
does that.
I wouldn't, but I would say, well, and I think it makes sense to do it at the end and not at the beginning. But basically indicate that whenever I've used the phrase cause the death or committed the killing or the other places, keep in mind that the Commonwealth is proceeding on a theory that the defendant participated, whatever, the first 2-3 sentences from the introduction of the joint
We
venture.
have no objection to that.
Because I
And
think
Your
it's...
Honor, we agree, the clarity is important, and I think the
Right.
court that's your intention, so we...
Do you have any preference as to whether that should be given before I use the words or after I use the words? And sort of at the conclusion of the murder charges for a second.
Could I have one?
I think before, Your Honor, just so then they'll understand.
Right.
But when you say it, they'll know what you're talking about.
I agree with that.
Okay, I
Thank
will.
you.
I will give the B, which is what we've argued on 18, your 18B, the Commonwealth's B is the extreme atrocity and cruelty. I'll give the language. On pages 6 through 9.
Your Honor, is that, I just haven't had a chance to,
I believe it's identical to the model.
that's my question. Okay.
Right. On second degree, I'm going to use the model, so it's sort of, I'm not going to repeat. I'm going to use sort of the model that just says I've already given you those instructions when extreme atrocity or cruelty has been charged. Do you want to, I'll hear you with respect to your argument on request 14 to eliminate third prong malice.
Yes, Your Honor. Once again, I'm asking for something that the SJC has not approved, which is that third prong malice is, number one, it does not, it simply does not, number one, is too vague, it's too close to manslaughter, and number two, Your Honor, it just does not comport with the whole mens rea requirement that generally permeates our jurisprudence in the area of homicide. So I'd ask that the court not instruct on third prong malice.
Obviously, we would ask you to stick to the law that's in existence, Your Honor. Thank you.
Thank you. The court declines the defense request to eliminate the third prong of malice from both extreme excessive cruelty and murder in the second degree. Request number 15, and the Commonwealth has the opposite request, so I'll hear counsel on that.
Again, Your Honor, we recognize that the SJC has held that such an inference is permissible. It's our position that it diminishes the Commonwealth's burden of proving malice beyond a reasonable doubt and is therefore unconstitutional under the 5th, 6th, and 14th Amendments in Article 12.
Mr. McCullough.
No further, we're just asking you to stick with what the case laws are suggested is permissible.
We'll give the language requested by the Commonwealth on the bottom of page 10 and the top of page 11. And the court will give the last paragraph requested by the Commonwealth on page 11.
And we would object to that, Your Honor, as well.
I believe the language is exactly that in the model, and the court will give it. The 16...
I think we've already gone over that.
Yeah, dealt with that. I think you were going to reserve on that one.
I'd like to read the cases. The
Sure.
court mentioned Gonzalez. If we have anything to bring to the court's attention,
Sure.
we'll do that.
And they say
before
those
Monday.
are drug cases, but I think...
Yes, I'm not suggesting we will have anything, but I'd like the chance
Sure.
to look, Your Honor.
Request 17, I would wish to be heard on that.
17, Your Honor, I think that there is certainly evidence in the case from Ms. Jenkins that Mr. Hernandez imbibed alcohol. I think she said we were both very intoxicated that night or something to that effect. Also, there's evidence both from Ms. Jenkins and from the video that Mr. Hernandez smoked marijuana that night. And I think the state law in Massachusetts is that when there is evidence of intoxication, that this instruction should be given at the request of the defendant.
I don't disagree with that suggestion, Your Honor, and just ask that we
I'll use
track
the model. I will
Thank you.
track the model, so it will be given in the context of deliberate premeditation, extreme atrocity, cruelty, and 3 crimes of malice for murder on extreme atrocity, cruelty, and for second-degree murder, and I will use the language from the model. That covers the requests that you both made. I have a... Oh, no.
I had one more this morning,
Yes,
Your
you
Honor.
did.
I'm sorry for submitting it late.
No, I did, and I have the... I don't know whether you've had a chance to look at it or seen the Kelly case. The quotes are directly... You have...
I did just look at the Kelly case here this
It's
morning.
easier for you to see it other than on a phone, but the first sentence is a direct quote from Kelly. If given, I would also give it in the context of the other 2 sentences from Kelly, that the inferences drawn from the evidence need only be reasonable and possible and need not be necessary or inescapable, and that a conviction may not rest on the sentence you've requested, and then the sentence that which that was the sentence that preceded the one you requested, and the sentence that followed the one you requested, which is the evidence of a defendant's guilt may be primarily or entirely circumstantial.
And that was what I noticed in reading the Kelly case, that those sentences were missing, Your Honor. But I think that the real essence is that you're going to give, I believe, an instruction on inferences
Right, this
already.
is just their requested
Right,
language
so-
of it.
And I object to that because, in fact, portions of this really have to do with reviewing a jury's verdict. So the court's sort of discussion, as you indicated in the first sentence, that conviction may not rest on the piling of inference upon inference or on conjecture and speculation. That's what the court is doing in retrospect, trying to make that determination, whether because they're reviewing whether a reasonable jury could have come to these conclusions in the absence of conjecture or speculation. And so I think it's two different things. I don't think that the court in Kelly was suggesting that this should be an instruction. In fact, what the court is doing is discussing when reviewing the denial of a motion for required finding of guilty, and that you'll see to employ conjecture in choosing among the possible inferences from the evidence, presented the evidence is insufficient to sustain the Commonwealth's burden of proving guilt beyond a reasonable doubt. What they're doing, Your Honor, is simply looking retrospectively at a jury's thought process based on the evidence. And here, where an inference need only be reasonable and possible, that's the jury's sole function to make those determinations. I think that to the extent that it inserts what the court's role is retrospectively, I don't think that that's proper for a jury instruction.
Well, Your Honor, I think this represents the most up-to-date language from the SJC on the quantum of evidence required to convict, and that's why it's part of the sufficiency of the evidence treatment in Kelly, but that's also obviously applies to a jury. So, excuse me, I think it's completely appropriate that the jury be instructed in this language, particularly in a case which is built on circumstantial evidence and where the Commonwealth is asking the jury essentially to convict on the basis of inferences. I think the court should give the jury as much guidance on that subject as possible, and that's exactly what this language does.
Just taking the first sentence, I think the problem with the language, turning that language as is into a jury instruction, is that it, because there's no definition of piling on, is that it suggests that you can't have an inference on an inference. Whereas in fact, the case law is that you can build on inferences as long as the chain doesn't get broken. I would, there's some language that the court has said we don't need to give because it's often not necessary, but we can give the language such as you should not pile inference upon inference until the pile gets so high that it tips over logically, or the chain gets so weak that it doesn't hold together anymore. I would give that language, or language that an inference is not improper. The language in the Vega case, it's not improper because it builds on an inference. If the primary inference is reasonable, and each secondary inference must also be a logical and reasonable conclusion from the prior inference.
Well, Your Honor, I think the most important sentence in this, in Kelly, is a sentence where they're quoting Rodriguez, or Rodriguez quoting Croft, in old case. If a rational jury necessarily...
I already got there. We're
okay.
just...
All right, go ahead.
We're just
Sorry.
on the first sentence.
Yes, sir.
Just dealing with the first sentence.
Okay.
And I believe that the standard inference instruction already includes the words conjecture or surmise.
Right, and it's just, so I'm just dealing with I think the concept of piling on by itself is suggested on the first sentence.
Okay.
The court will be telling them that they can't speculate and they can't, and that any inference has to be reasonable and possible and logical and natural, which is not to remote in the ordinary course of events. And then to specifically say you can't have piling on by itself, to a jury, I think would mean they can't do an inference on an inference.
Well,
so as I say, I would give an instruction. I've offered two. One is you should now pile inference upon inference until the pile gets so high it tips over logically, or the chain gets so weak it doesn't hold together anymore, which is the concept of, I think, what they're saying in this case.
I think Your Honor is correct. I think what Your Honor is doing is essentially recognizing that the SJC sort of used shorthand in this paragraph, and the court is giving more substance to what is meant by that, and I think that's totally appropriate.
So I will give the previous sentence, as I do always, that it only need reasonable and possible, need not be necessary or inescapable, and I will give this sentence. I will give the piling on concept in the way I've just described, that there's no disagreement over. And then I will give certainly the concept that circumstantial evidence is competent to establish guilt beyond a reasonable doubt. Turning to the next sentence on conflicting inferences, there's been a lot of discussion lately, or there's been case as the issue of using that phrase that it's for the jury to determine where the truth lies, that it's really the Commonwealth's burden in a case, and that suggesting it's for the jury to determine the truth may ask the jury to form some free-floating function apart from determining the burden of proof. So if I was to give that sentence, it would be the quote from the case: if from the evidence conflicting inferences are possible, it is for the jury to determine which inferences, if any, to draw, for the weight and credibility of the evidence is wholly within your province.
Your Honor, that's why I did not include this sentence in my request. I don't think...
That's your second sentence.
Right. I guess we did include it. I guess, Your Honor, I don't think we should ask for that, because I think, in fact, I would withdraw the request for that sentence. I don't think it's for the jury to determine where the truth lies. I think it's for the jury to determine whether or not the Commonwealth has proven its case.
Exactly. That's why. So that's...
I agree with that.
So you're withdrawing the second
Yes, Your Honor.
request for second sentence. And I don't, in the intro to the charge, when I did talk about the jury's function, I don't use the language of it's the jury to determine where the truth lies. Will add to sort of my standard inference instruction simply, if from the evidence conflicting inferences are possible, you may not employ conjecture in choosing among the possible inferences from the evidence presented.
That's fine, Your Honor.
And there is a standard instruction on not speculating and not engaging in flights of fancy.
Yeah, Your Honor, I'm just, conjecture is a term that lawyers use all the time. I don't know if it's a word that jurors are familiar with. I don't know if there's a neutral synonym for conjecture. It's not a word that's
Right.
used in common parlance by a lot of people, I would submit. I would suggest speculation or guesswork or
Right.
something like that.
I do all of that.
Okay.
I do
all right.
conjecture, guesswork, speculation.
Okay, as long as they're all out there, that's fine.
Flights of fancy.
The more the merrier, Your Honor.
I have them all.
Okay.
And then I had a few other things to raise, still on the charge and then some non-charge matters. And I raised some of these as to why although they're somewhat standard, sometimes I'm asked not to give it, and so I just wanted to run some of these by you. When I deal with the presumption of innocence, to add, you shall draw no inference from the fact that the search warrants may have issued, that defendant was arrested, and then I always do that he was indicted, I think.
That's fine, Your Honor.
I didn't get a sense that there's any real issue on business records as to what these are.
There's no issue, Your Honor.
Neither of you are requesting an instruction on the jury determining whether those are business records.
No, Your Honor, not for us. Thank you.
We've had a few exhibits, I think, that were compilations, the FBI exhibit, and then I think there was a previous a map that was done after the fact with cell tower, that were both from one of the cell tower witnesses. And so I gave part of that limiting instruction during the trial as to whether you want me to repeat the limiting instruction, not identifying the exhibits, but a few exhibits purport to be compilations based on records introduced into evidence, and keep in mind that doesn't purport to be the original compilation maker of the business records, and keep in mind it's a compilation admitted because it may be of assistance to you.
I think that's fine, Your Honor. Your Honor, can we just go back to the last one for just a minute? I'm sorry. The one about they shouldn't draw an inference from arrest and indictment.
Sure.
I think because there's been a lot of references to a grand jury investigation.
Oh, I do. I have that too.
Okay.
It's a separate.
Okay. Thank you.
Gotta wait till I get to G. So you both, or you're...
We request that instruction, yes, Your Honor.
I'll give an instruction on chalks. We've had a lot of chalks. I'll give an instruction on expert testimony tracking the SJC model in Hines. Grand jury, I will give an instruction that the fact that there may have been a prior proceeding, such as grand jury proceedings, doesn't change the presumption of innocence and not to draw any adverse inferences. I don't know whether you want any reference at all to during the trial that you heard certain facts were judicially noticed, you may but are not required to accept as conclusive those facts.
I think the only one had to do with the measurements, Your Honor. I don't think we really need an instruction on that, do we?
You took judicial notice of the state law regarding
Right.
operating hours for
okay.
licensed establishments,
That's
but
right.
I don't think that there's a need for...
We're not going to speak to that. I don't think we need an instruction.
Was weight. Kilos is...
Right.
Do you want me to repeat the instruction on photographs, sympathy, etc.?
Yes, Your Honor.
Now, there are a series of potential instructions on prior bad acts, so I wanted to go through those with you and see which, if any, you want me to give. They would reflect ones given during the trial. Why don't I read to you what I've sort of drafted? Defendant is, as I've told you, the defendant is not charged with committing any crime other than the charges contained in the indictments. To the extent you have heard mention of an object that may have been seen in the personal possession of the defendant or in his residence, such evidence cannot be considered by you as proof that the defendant has a propensity to commit any of the crimes charged or as evidence of bad character, and you may not use it to conclude that if the defendant possessed a firearm on some other occasion or had a firearm in his residence, he must have committed the offenses with which he is charged. If the Commonwealth has proven that the defendant possessed or had in his residence a firearm that could have been used in the commission of the murder of Odin Lloyd as the murder weapon or as a weapon with which the defendant or another whom he was allegedly aiding and abetting was armed during the commission of the murder, you may then consider such evidence to the extent you may find it relevant solely on the issue of whether the defendant had the means to commit the murder with which he is charged or to arm another with whom he was aiding and abetting with the means to commit the murder charged. With respect to the firearm allegedly seen in the hands of the defendant in Florida, keep in mind that in order for you to consider it for the limited purpose I just described, the Commonwealth must prove that the defendant had access to this weapon in Massachusetts at the time of the murder. With respect to testimony about objects allegedly seen in a box in the defendant's residence, if you credit such evidence, you may consider it to the extent you find it relevant solely on the issue of the kinds of things that may have been kept in that box. You may not consider this evidence for any other purpose whatsoever, and to the extent you heard mention of the use of marijuana by the defendant, such evidence also cannot be considered by you as proof the defendant has a propensity to commit any of the crimes charged or evidence of bad character, and you cannot use it to conclude if the defendant smoked marijuana, he must have committed the offenses with which he is charged. If you credit evidence regarding marijuana use by the defendant, you may consider such evidence to the extent you may find it relevant solely on the issue of the relationship between the defendant and Odin Lloyd and the defendant's state of mind, motive, and intent.
Could we huddle on that for 2 minutes?
Sure.
Thank you. Your Honor, we'd like to raise, I guess, three issues with the court's proposed instruction. First of all, with respect to the instruction about kinds of things kept in that box, and as I understand, that would relate to the idea that the box that Mr. Bradley saw in the basement had a gun in it, and therefore the jury could infer that it may have had other guns in it, and the jury could infer that that was a box that Ms. Jenkins took out of the house. I think that that line of inferences is completely undermined by Mr. Bradley's recognizing the photograph that Mr. Rankin showed him, which is a safe, little safe in the basement that was an exhibit in this case, because that box was in the house when the police went there on June 22nd and conducted their search and inventoried the contents of that little box. And that's the box Bradley was talking about. So that could not have been the box that Ms. Jenkins took out of the house, and therefore I don't think that should be suggested to them.
When we had the motion to eliminate, I'm not sure, or even before his testimony, they've never been, and the court indicated that it was only allowing in the testimony for what was in the box, for the very theory.
I think that's right. I think
but it was not pointed out to the court.
Well,
that,
well, I mean, frankly,
so it came in for that reason.
I suppose, I suppose we probably could and should have asked the court to strike that testimony, since once he identified that box as the box he was talking about, I think that theory is totally gone. So we would, at this point, we would certainly object to the courts making singling out that at all as something.
Okay, so you're not, this is just what, I gave instructions during the trial. You're not asking for any instruction on that?
On the box, no, Your Honor. So that's number one. Number two, I guess with respect to Mr. Hernandez and Mr. Lloyd and marijuana.
Are you asking for any instruction on that? You did at the time, at one point in the trial,
right,
request that.
Especially we don't want any instruction that uses the word motive, because I don't think there's been any testimony.
So you're not requesting instruction on the use of marijuana?
That's right. And then third, Your Honor, we don't want any instruction about this object, because I think...
So you're not requesting the court to repeat any of the prior bad act limiting... I do say to them, the limiting instructions I gave to you, in the trial, all apply, and if you don't want me to repeat them...
Your Honor, that's correct, Your Honor. We don't want the court to repeat them.
Okay.
Mr. Rankin indicates that he did move to strike. I'm sorry.
Testimony about the gun, because Bradley said that this is the box that I saw in it. Because
right. Mr. Rankin reminds me that he did move to strike Mr. Bradley's testimony about the gun that Mr. Bradley said he saw in the basement after Mr. Bradley identified the box as matching the exhibit, and I believe that the court denied that motion.
Okay. So I will not put any prior bad act instructions in the charge.
And Your Honor, just with regard to that, one, I don't believe Bradley said that was the box. I think he said it was similar to a box. Two, there was other box, a lock box there. Three, in the basement. Three, Cheyenne Jenkins testified to getting a cardboard box, and inside it had other boxes, and she then described the shape and the size of it. And I think in some ways, the other box, had she found this box, that would obviously have gone as well. It had .22 caliber ammunition in it, so the suggestion that there was more than one box, meaning the box that got left behind, the one they showed him a picture of, had .22 caliber ammunition. One would think if she was cleaning them out and she found that one, that would have gone as well. So, but I don't think at this time it's some basis to suggest somehow that...
Right. Thank you. Prior inconsistent, we've had various prior inconsistent statements, I'll give that, and we had at least one prior consistent, Mr. Bradley. So I will give both of those. Limited for credibility purposes. There have been various statements that have been made to the defendant, either in writing or sometimes Ms. Jenkins, some of which text messages or statements by Ms. Jenkins, or some of which clearly were statements of intent, I can give an instruction that testimony regarding statements that may have been made to the defendant other than statements of intent were admitted into evidence with respect to the defendant's knowledge or to give the context of any responses the defendant may have made, and not for the truth of any fact contained in the statements.
That's fine, Your Honor. We would
I think that's
request
a fair statement, Your Honor. Thank you.
We had a stipulation, and I'll...
Your Honor, there's going to be one more stipulation on Monday morning, I think.
Okay. Then sort of non-charge issues. I have and I realize it's a holiday weekend, so I'm not asking anyone to work this afternoon, but it's always nice to be able to get the exhibits to the jury pretty close in time to when the jury goes in the jury room. So they really need to be checked for Social Security numbers and credit card numbers on all these various business records and billing records. There very well may be ones that counsel didn't catch. I know some were being caught as they were put on the presenter. There are some exhibits that are not going to be able to go into the jury at the same time as other exhibits. So the .22 would not go in with the .22 ammunition. I don't, if you have a preference, you can let me know.
What kind of preference, Your Honor?
The phone, Mr. Hernandez's phone, and I think maybe Mr. Lloyd's phone, to the extent that there were text messages from either of those phones that were on the presenter, that's what sort of, those messages are in evidence, and I'm not sure we've ever introduced the, maybe we have, maybe there is, but the screenshots. But I would think that the phones themselves should be in some sort of heat-sealed bag, the way we do with drugs, so that the phone isn't handled and where they could access other messages or other contacts or things that are not in evidence.
Could we speak on that one, Your Honor, for a moment?
Sure.
Thank you.
Taking the battery out of the phone so they can't use it. I think some of those phones probably could be manipulated through the plastic. So we could put it in a heat-sealed evidence bag and then remove the battery. And then we would be able to manipulate it. And I don't think that would distort the data.
But you could still, battery, can you still check text?
No,
you do.
Your Honor, I think that presents sort of a logistical issue for us. I think we need to see what else is on the phone that we may want to put in during our case. So I would like...
You may. You certainly, I assume we've gone through everything on the phone by now. But certainly, so you can deal that over the
So I
weekend.
guess I'm saying, Your Honor, is that we may want to put additional
No, I understand.
screenshots on, and then once we get what we need out of the phone, we can do what the court
Right, I
suggests.
just thought that the two of you,
Yeah.
whatever's coming to evidence from the phone, there should be screenshots, and then the phone can be put without its battery, because I presume even with the battery, you could probably manipulate it into some heat seal.
Right, as long as we have an opportunity
But
to
both-
take what we want off the phone before that happens,
No,
yes, Your Honor.
definitely, and that goes for the two phones.
Yes, Your Honor.
So,
That sounds agreeable, thank you.
and do I get from Mr. Ressett's testimony yesterday that the jury would be getting instructions how to use the DVR?
Yes, Your Honor, I think that was marked as one of the exhibits, so hopefully they followed along his little tutorial as well.
And they would therefore have access both to the original and the clone?
Yes, Your Honor. Oh, I'm sorry, the original, Your Honor, is in the bag, the sealed bag. So to the extent that, I think he had indicated that that could be then be damaged or, altered. So I guess it would be the clone.
I'm sorry, Your Honor, is there...
Did you hear what,
I didn't, I apologize.
we're talking about is it DVR? What would be available to the jury?
I'm sorry, I apologize for...
The cloned hard drive and the original is in a heat sealed bag.
That's fine, Your Honor.
Well, it will be in a heat sealed.
Right.
That's fine.
And the other clone,
Okay.
yeah, is available.
Any redactions that were agreed to have been, were going to be made that haven't been made should be checked. I think you were pretty good at both sides at making redactions pretty contemporaneously, but...
I think we have, Your Honor, but we'll check
Since
those.
they haven't. In a case with this many exhibits, the jury from time to time asked to see an exhibit list. The clerk's exhibits list are not necessarily a form that may be suitable to be sent to the jury. They may be more description of what is on a picture or in an exhibit than one or both of you may think is appropriate. I believe you, so what I would suggest is that if the two of you, or if both sides want to come up, modify, examine the clerk's list and want to have a modified list at the close of the entire case, and either want to send that list in initially or wait to see if the jury requests it. I just didn't want, if the jury does request it, that a lot of time is spent editing the clerk's list, so that you might look at that beforehand. Sometimes they're very descriptive as to what's in something, and maybe it's an issue where that indeed is a photograph of X or something. Those are the only issues I had.
I'm just looking forward to the time available for the closing.
Right, the rule is 30 minutes?
I'm sorry?
I think the rule is 30 minutes?
I didn't think there was a, is that 30? Your Honor, obviously it's been an extensive case. I would ask for an hour and 30 minutes, Your Honor. I don't think, I think it's reasonable.
I'm sorry, I couldn't hear what you said.
I'm sorry, I would ask for an hour and 30 minutes. I think there's extensive evidence in the case, arguments to be dealt with, issues. I would think a case that goes for 8 weeks, the normal case, 30 minutes, we're normally trying cases 3 to 5 days. So I think it would naturally require time in that order. Thank you.
Your Honor, I think 45 minutes, something in that neighborhood should be sufficient. That's what we would request. We can do it in 30 if the court wants to order 30.
will allow the request for a 90-minute closing. The other question I have is, does the Commonwealth intend to use any photographs at all in its closing of Mr. Lloyd?
Of the autopsy-type photos, Your Honor?
Any at the scene, any photographs at all?
Yes, I would think there would be some, Your Honor.
Sense of how many, you think?
A couple, a few, Your Honor. I don't think
Which you'd be putting on the presenter?
I don't believe I would, Your Honor.
So you'd be showing them to the jury?
If anything, I would just show them, right? I find that too distracting, so...
So they'd be shown to the jury?
Yes, Your Honor.
Okay. If that changes, then I would like to be advised, and would then have a discussion about whether the presenter should be used or whether the monitors should be, public monitors should be turned off.
Fair enough, Your Honor. Thank you.
If you're going to simply display them to the jury, I don't have that issue.
Thank you.
Thank you.
Your Honor, the only other thing that I can think of, as far as when the schedule for next week, is it fair to say that we're not going to do arguments and charge on Monday?
Yes.
Okay.
I think that's fair. I don't want to separate arguments and charge. I think we're going to have a delayed opening, given the voir dire, and so it'll either be Tuesday or Wednesday, depending on the length of the defense.
I'll check with my colleagues if there's anything else that I've missed. Thank you, Your Honor.
And if we don't exhibits or any of the other, the clerk's list, etc. Thank you. Have a wonderful holiday.
Thank you, Your Honor. Thank you, Your Honor.
But all rise.
Yes, sir. Yes.
Next weekend, you can bring it in.
Let's go to standing recess.
Because we just have the one for the stickers on it, that have all the writing on it.
Yeah, I think we have
I guess we're going to look at these phones and figure out.
Yeah, you know what? I have some scrolls.
I'm sorry, what? You joined us.
We have video scrolls of, they're illegible, and we gotta look at them. I didn't hear what your question was.
Video scroll. How are we going to work in about getting it?
Well, I like to look at both of the phones and see all the text messages that are there.